All right. Yeah, I will let you know when you're quiet in a second.
Thank you. Hi, everybody. I'm McLaughlin. I'm an attorney based out of Chicago. My focus is animal law and environmental law. And today I'm going to be talking with you about ESG. It's a dense topic, so stick with me, and I'm going to try to simplify it a little bit as we go along. So, overview of the presentation today. We're going to describe what ESG is and go over some of the basics. And then what I want to do is explain how these laws are going to work in the United States potentially, and what ESG looks like in the EU. After that, I'm going to do a comparison of those two laws, and then we'll talk about what we can do as lawyers to try to implement some of these ideas. So ESG stands for Environmental, Social, and Governance Reporting. These are non-financial reporting metrics for companies. And the reason they're important to us is because environmental issues, social and governance issues, they intersect with a lot of the things that we do and a lot of the things that we care about when it comes to animals. So what I did here is just listed a few examples for you to think about. So the environmental prong of ESG, we know that industrial animal ag causes anywhere between 11 and 20% of global GHG emissions. So you would think that companies involved in that would need to report under the ESG rules. We know it leads to deforestation and climate change. The social factors, this is not a complete list by any means. There's so many different things that the industrial animal ag industry does that might fall under these categories. But we know that we've seen child labor in cleaning machines at night at slaughterhouses. We know that indigenous persons have been displaced off their lands. We know that there's a lot of employment violation going on here. And governance, that could be political activity or lobbying of the industry, and ethics falls under governance, corporate ethics. So one of the things I'm going to touch on is EU animal welfare under a specific type of reporting. One thing to note is there are a lot of different metrics for ESG, and that's why we're talking about this today, because the lack of standardization has been a real problem. So companies that are reporting non-financial factors can report it any which way they want, and it can make it seem like they're doing the right thing for people, animals, and the environment, but that's not necessarily the case. One of the things I want to focus on today is the environmental prong specifically, and the emissions reporting, the GHG emissions that have to be disclosed. And those align with the 7 Kyoto Protocol gases, which are listed here. And we know specifically that industrial animal ag produces a lot of CO2, methane, and nitrous oxide. So one of the things that we look at in the environmental prong is what type of emissions is a company making? So they divide them and categorize them by scope. So scope 1 are direct emissions from the source. So that's the company's own emissions at the site where the company is, or it could be where any of their subsidiaries are as well. Scope 2 is indirect. That's emissions from energy and utilities that the company is paying for and using. Scope 3 is indirect, and this is a hot topic really, because this focuses on the emissions within their value chain. Typically the top of the value chain. And to basically explain what that value chain looks like in industrial animal agriculture, I don't know how familiar you are with how big ag works, but typically the way it works is they don't always grow their own animals. They will provide animals, they send them to a contract grower who signed a contract with that company to grow the animals based on the specifications of the contract. Then when those animals are fed to the proper size to go to slaughter, the big ag comes, picks them up, and takes them to slaughterhouses that are owned by big ag. So we know that these CAFO models are spreading globally, and companies that are using this model and having contracts that are non-negotiable with contract growers, they have control over the front part of their value chain because they're dictating that to the growers. The growers cannot make any changes to that. And there's an imbalance of power here. So what happens is it becomes the grower's responsibility if there's any pollution or emissions or anything linked to these animals. So Big Ag is able to, offload it, and the growers would be responsible for their problem. This is really important because greenwashing is rampant and has been rampant. You'll read a lot of company reports that talks about how green they are, how sustainable they are, how well they take care of their animals, and many of us know that that is not necessarily truthful, right? They provide us data and they provide their investors with data that don't align with their actual practices. And until there are ESG reporting rules or frameworks that have to be implemented to report your non-financial disclosures, it's been like the wild, wild west. You can report it any way you want, and that's been allowing these folks to greenwash. So ESG laws, what they're gonna do is they're gonna create systematic frameworks that are chosen by the country. So the US is choosing different frameworks than the EU, and I'll talk a little bit about that. But it's gonna make it unlawful to make these misleading statements that they've been getting by with all along. Another thing I want to point out, and I know that we're not focused on corporate law usually in animal law, but when you're reporting, you need to report anything that's material to investors. It's like what a reasonable investor would want to know if they're going to put money in your company. And there are two different types of materiality that differentiate the ESG rules in the United States versus the EU. The first is single materiality. So this is disclosing material risks to the company that the company is facing due to climate change, and looking at how they're going to mitigate the risk to the company so that they can continue to run their company, run their business, and make money. In the EU, double materiality reporting will be required. So that's the same as the first one, disclosing the material risks that the company faces due to climate change. But they also have to disclose the material impacts that the company's operations have on the environment and society. So one is an outward look, that's an outward looking parameter to see how that company is damaging the environment, hurting animals, hurting society. So ESG in the United States. Unfortunately, we don't have a comprehensive framework. The United States is just focused on the E prong, that's the environmental prong. It's the scopes of emissions for greenhouse gases and things like that we talked about earlier. The U.S. rule is going to be called the Enhancement and Standardization of Climate-Related Disclosures for Investors. I know that's a mouthful, but it can be found in the CFR under these CFR numbers. So it was effective May 28th, but the compliance dates are really up in the air because what happened is, as soon as the SEC released their final rule, companies and states started to challenge the SEC, and the complaints, varied, but oftentimes it was, you are the Securities and Exchange Commission. You need to focus on how much money a company is making. You can't tell companies what to do as far as climate compliance, and it's outside of the purview of your governmental agency. So what the SEC started to do is just decide that they're going to take all these cases because they're being sued by over 25 different states in the U.S. as well as private entities. And they decided to voluntarily stay the rule. So the rule is not in effect right now in the United States. There's a lottery system, so everything got consolidated in the 8th Circuit Court of Appeals. And so we're not going to know how that law is going to shake out for a little while. So in the United States, the rule that was released this year covered actually had some changes than what the initial rule that they had put out for public commentary 2 years ago had. Importantly, they chickened out, to use that term, and got rid of Scope 3. And this is really important because if you remember when we were talking about the contract growers and like what a mess, farming in capos is, that gets all of this stuff out of the reporting. Now, it could be argued, and I'm not going to go into detail about it, that because the company doesn't own, but they control those growers because the growers cannot modify their contract. If you own or control another entity, that would fall under a scope 1 reporting measure, and that's what I would say. So it's going to depend on how these things are, how they come out, and whether even there's going to be a rule. I'm just going to skip over this. This is the compliance schedule that's not in effect, but it was to start, with these are large companies and all the definitions are here. But we're not going to cover this, just too much detail for this presentation, but I can make my slides available. So what we're concerned about is that the SEC rule is going to go away. So you might have heard of something called Chevron deference. So that was a 1984 case where the Supreme Court made a decision based on how much leeway a government entity like the SEC, a government agency, has to make their own rules. Like how far can their influence extend when they're making a rule? So when they're looking at interpretations of the law from a government agency, they say, well, is the statute ambiguous? And if so, is the agency's interpretation of that statute reasonable? But you might know that Chevron was just overturned by the Supreme Court, and we don't know how that's going to turn out. So we know that the SEC has many lawsuits against it for this ESG rule right now. And if those are appealed all the way up to the Supreme Court, then it's going to be the Supreme Court's decision to say, okay, SEC, do you have or do you not have authority to request non-financial disclosures? Can you do that? So the nice thing about the EU, and where I want to spend most of our focus today, is that the ESG law in the EU is going to be comprehensive. So it's falling under the Corporate Sustainability Due Diligence Directive, and all of these rules are going to be part of the Green Deal. And the aim of the directive is to foster sustainable and responsible corporate behavior in companies' operations across their global value chains. EU member states have to incorporate this into their own laws, and they have a deadline about a year from now, next July, to get that incorporated into their own laws. Specifically, their ESG rule is the Corporate Sustainability Reporting Directive, and it's going to be phased in. This year is the first year that data is being tracked, and large public EU companies are going to need to disclose next year. So they're going to have to report all of these different data points. But importantly, I want to tell you that the CSRD framework, or the Corporate Sustainability Reporting Directive framework, it was developed in collaboration with an existing global framework. That existing global framework is the Global Reporting Initiative, the GRI. It's a standardized framework, and that GRI framework has sector-specific parameters that the company has to report, and that's very important here because that means, and I'll touch on it later, that the agriculture sector has its own reporting requirements. This is a reporting schedule, and I wanted to point out that the large EU companies here are going to be the first to have to report. This green bar is the sector standards. So in 2026, it got pushed out 2 years. They're going to need to report based on their sector-specific parameters. The other reason that this could be a game changer is because it's not like the SEC where all of the companies that are reporting to the SEC are publicly traded somewhere in the United States. For the EU, it's going to be different. It will include publicly traded companies, but non-EU companies that might not be publicly traded and their subsidiaries are going to need to report. And that is a huge game changer for us because we know a lot of these ag companies are also private companies, but we know they're big. So it's going to include all 3 scopes and the Kyoto Protocol GHGs, but most important, I want to touch on government. The governance prong, E, S, and G, governance, and the sector-specific reporting. And the sector that applies to animal welfare is going to be under GRI 13, and specifically animal health under 1311. And I just want to take a moment to look at this, and especially the underlying portions. Animal health and welfare refers to an animal's physical and mental state in relation to the conditions in which it lives and dies. The 5 freedoms of animal welfare are freedom of hunger, and we know the rest. But GRI 1311 covers impacts on animal health and the 5 freedoms of animal welfare. These are just some great quotes out of the GRI 1311. You can see there that it's looking at a lot of the things that concern us: dehorning, hot iron branding. It's recognizing that these things cause stress in animals, and so they're going to have to report like what they're doing and how they are keeping animals, their animal husbandry conditions. So specifically, I want to touch on 4 sector standards under 1311.1. So these are the things that the GRI thinks are material and will need to be reported for any company that deals with animals. Describe policies regarding processing of animal products, animal transportation, handling, housing and confinement, and slaughter by species. Describe the approach to animal health planning and involvement of veterinarians, including the approach to using anesthetic, antibiotic, anti-inflammatory, hormone, and growth promotion treatments by species. These are material that must be reported. The other 2 material items that they have here are describe commitments for responsible and prudent use of antibiotics, and describe the results of assessments and audits of animal health and welfare by species. I also want to touch on 1311.3, which is sector disclosure about the survival percentage of farmed aquatic animals and the main cause of mortality. It must be disclosed as material. So if we look at the differences, this is a very simple comparison. So the US rule is climate focused, but the EU is covering all 3 prongs. US will apply to only publicly traded companies, but we're going to be able to cover large non-public companies as well as their subsidiaries in the EU. The SEC is going to be the enforcement mechanism in the United States, and on the other side it's enforcement by individual EU member states. Scope 3 is left out in the United States, and we know there's a lot of legal challenges for the SEC, so this might go away. And governance under the animal welfare GRI specifications are going to be very important to us in the EU. So we've already discussed this. It's going to be double materiality. So in the EU, you're going to have to disclose the material impacts that your company's operations cause to society and the climate. Has a big overlap with industrial animal ag. So U.S. enforcement and rights of action. So it could potentially be just the SEC enforcing. There is potential state actions on behalf of their citizens. So in a similar case, the New York Attorney General brought a case against JBS. So states can do that to protect their citizens. Investor actions and class actions for material non-financial disclosure misstatements or omissions. So an investor, if they get their prospectus or information on a website and they think that, okay, this is not what the company said it's doing and it doesn't line up, they can bring an investor lawsuit for that. And then climate impacts focus, we know that there's no sector-specific compliance related to animal welfare in the United States. But what's exciting is the actions you'll be able to take in the EU. So the member state can enforce, but this law is going to allow both the individuals that would be impacted, but also it's got a private right of action for organizations, and that includes NGOs, trade unions, is if they have relevant experience in this topic, to be able to file a complaint with the company. The companies have to put complaint processes in place. Those processes have to be transparent and publicly available. And the complainant can request complaint status, decision reasoning, and meet with a company responsible to discuss impacts and potential remediation. So this is a game changer, essentially. It could be. We're going to see how it's implemented. We're in the first year, and these GRI 13 animal welfare standards are delayed by 2 years. All the sector-specific standards were delayed by 2 years, and they're going to be first reported by the big EU companies based in the EU that are publicly traded there, but all the other ones are going to be phased in as well. So this could be a potential lever for advocates and organizations to target companies and question their animal welfare practices when it comes to farmed animals. Thank you, and if you need a copy of the slides, just let me know.